Hey folks, I'm attorney Roger P. Foley, and today, on a Saturday, dressed in my weekend clothes, I'm going to talk to you about domestic violence cases, and specifically, we're going to talk about waivers of prosecution. So here's the normal scenario that occurs. A man or a woman is arrested for domestic violence. We all know what domestic violence is. It's the touching or striking someone against their will who happens to be a loved one, a family member, a roommate, a boyfriend or girlfriend, etc. So that person is arrested. And the alleged victim in the case, let's just go with the very typical scenario. Husband-wife. Husband is arrested for pushing or touching his wife against her will. And now, after he has been arrested, she would like to do something to help him. She doesn't want the charges to go forward. So she contacts the state attorney's office. She talks to a victim advocate. They listen to her and nothing happens. The case seems to be proceeding. And they explain to her that even though she doesn't want the charges to go forward, that it's the state attorney's office that actually makes that decision. It's their case to either go forward and prosecute, or it's their case to dismiss. She, the alleged victim in the case, doesn't have a choice in that matter. She can say what she wants to say, but they decide whether or not they're going to prosecute her husband. Okay, so what happens? As a defense attorney, I'm often contacted by an alleged victim. An alleged victim says, hey, it's my understanding that my husband retained you, and what can I do to help? Well, the first thing that you have to tell an alleged victim is, I don't represent you. I can't give you legal advice. I can't tell you what to say or what to do or how to act. I can provide you with a document called the Waiver of Prosecution. I can tell you that if you fill it out and forward it back to my office, that I will forward it to the state attorney's office and make sure that the judge is aware of it and the clerk is aware of it and the state attorney is aware of it. But I can't give advice on that. So I ultimately end up handing a waiver of prosecution. Normally, I tell clients that they can also acquire that same document or a document very similar, titled in the same way, from the state attorney's office or from the victim advocate. But again, I have those available, and I think I'm going to make them available on my website, whether the client's my client or someone else's client. I think it's a form that the general public should have availability to. So anyway, let's talk about the alleged victim. They contact my office and they say, what do I write, Mr. Foley? And I go, I can't tell you what to write. I can't give you any legal advice. Why is that important? It's important for a couple of reasons. One, as an officer of the court, I cannot persuade, influence, or, quote, tamper with an alleged victim. If an alleged victim contacts my office and says they want to do a waiver, the first thing I do is I let the state attorney's office know that I've been contacted by an alleged victim. And I forward them whatever documents or statements they may have shared with me. Again, I can't give legal advice. So what's one of the most common things, and I'm sure this happens in other criminal defense attorneys' offices, so I just figured I'd make a video of it. What happens when the alleged victim comes in and says, attorney, I want to make sure that this case is dismissed. You know, what do you recommend I say? I don't recommend you say anything. I can't tell you what to say. I can't tell you what to write. In fact, I can't even tell you, after you've read it and my office has notarized it, I can't even tell you if you did a good job, if you should have added something, if you should have deleted something. If you write, hypothetically, and I've never had this happen, but let's say you wrote in your report Yep, my husband choked me, punched me, kicked me, took my keys, took my phone. As far as I'm concerned, my ethics require that I forward that to the state attorney. Now, I have no idea why any alleged victim would contact my office and ask to do a waiver of prosecution and then regurgitate the same thing that they may have said to a police officer, a victim advocate, or a state attorney. But I guess, it's possible. But a waiver of prosecution, simply the whole premise behind it is the state attorney is looking for, they want to know everything that could damage their case, right? They're looking for the highest likelihood of success in acquiring a conviction, right? They're prosecuting your husband. They want to make sure that they have all their ducks in a row. Well, if there's an affidavit out there that says, you know what, when this alleged incident happened, or when this incident, obviously I talk like an attorney, when the alleged incident, when they say, when this incident occurred, I was stoned. I've been smoking weed all day. When I smoke weed, I get tired and I don't remember things. My judgment is cloudy. Or, hey, Mr. Prosecutor, I was drinking. We were out at a club that night. I had 5 margaritas and a couple of shots of tequila. Obviously that's important, right? Why would that be important to someone who's prosecuting a case? Or why would that be important to a defense attorney? Because if they were impaired, if they were under the influence of drugs or alcohol, that may impair their ability to properly recall things, right? If they had 15 beers, maybe they don't remember the whole night. Or another factor that often comes up is when people are mad and upset and the police are involved, a lot of times people accentuate things or make up things or exaggerate things, right? That occurs. So if there's an affidavit out there that says, hey, look, as much as I didn't want to do it, I was so mad and I sort of exaggerated the story, that may be important to the prosecutor who's making a decision to go forward on a case or not. Or a lot of times the victim may say something to the effect of, I was drinking. I was under the influence. When I drink, I get upset. I get angry. I tend to be a little bit of a violent drunk. I slapped my husband. I punched my husband. I pinched my husband. I threw a glass vase at my husband. And he then restrained me. So does the prosecutor and the defense attorney have an interest in understanding whether or not the alleged victim was possibly the aggressor in the case, and maybe the defendant was trying to protect himself, acting in a manner that was consistent with self-defense? Of course that matters, right? So again, I can't tell people what to write in a waiver of prosecution. I simply have an ethical duty to accept the document and forward it to the state attorney. There's so many factors that the state attorney looks at, but really I think the most important factor, and I'm pretty sure any prosecutor that had this discussion would agree, is they want to make sure that the people who they prosecute are in fact guilty. They want to make sure that the person that they're representing, right, the victim, right, they're representing the victim as the state of Florida. They want to make sure that that person is a reliable witness, right? What if that person, for instance, was testifying on Wednesday about them being a victim in a domestic violence case, and yet they had a pending case in the same county or possibly the next county for I don't know, a drug charge or another domestic violence charge. Wouldn't that be important to go when looking at their credibility, their reliability, and the likelihood of success in obtaining a conviction? These things matter. People exaggerate. People are often under the influence. I mean, I think out of all the years that I've represented, it always seems that people are under the influence, that the fights occur leaving a club or a party or a fiesta of some sort. And it happens. When people are mad, they exaggerate. Then you just have people who, for whatever reason, they have a argument with their husband or wife, and they just lie. They just literally lie because they want to make that person pay. And I'll give you an example. I've had cases where one of the two people, whether it's a husband, wife, boyfriend, girlfriend, two male partners, two female partners, I've represented everybody. And one partner says, I don't love you anymore, or I don't want to be with you anymore, or this relationship just isn't working out. And when they attempt to leave, the other person contacts the police and says, he hit me, she hit me, she choked me, he punched me, she threw a table at me, she stabbed me. Literally, I've heard all of it. And they contact the police. And what happens on a domestic violence case? When a domestic violence case call comes into police, police are on high alert. They know that something serious could be going on. They know that tempers are often out of hand, and they're at risk. When a police officer comes out to a domestic violence call, most of the time there's an arrest. Sometimes nothing has happened, and the officers may ask the people to split up, and one person goes spend the night at a hotel or at a friend's or whatever. But a lot of times, police officers make an arrest. So if a police officer comes out and a man or a woman says, my husband, my wife just hit me, pushed me, touched me against my will, they're making an arrest without any proof, without any evidence. And people say all the time to me, well, how is that? Just because she said I touched her, there's no bruises. I didn't touch her. Well, guess what? The police can still arrest you. And vice versa. The man says, oh, she hit me, she kicked me. Well, even if there's no bruises, the officers are going on these people's testimony, so an arrest is made. Remember, it's a lot easier to arrest somebody and take them for a ride than it is to convict somebody in a court of law. So these waivers of prosecution that you hear so much about, they're really just a simple affidavit, a statement under oath. They have to be notarized, and they tell another side. There could even be affidavits, and they're not called waivers of prosecution, but affidavits of witnesses. I've had clients who have come into my office and they go, look, I was arrested. I was at a party. There's 6 witnesses. My husband, was doing this, whatever it may be. But there's witnesses that can sign affidavits, and those are sent to the state attorney's office, because if there's a third-party witness that has really nothing to do with the case and they saw what happened, they can either be a benefit to the case or they can be a negative to the case. Most times when police officers come around and they make an arrest, if there's witnesses, they usually get a list of names, and then the state attorney forwards those names. But a lot of times I find that defense witnesses, the police don't look. Remember, the police are in the job, they're in the job to arrest people. They're not in the job of getting people found not guilty. So I don't find that they search out witnesses. So if there's a next door neighbor that saw the whole thing from the argument that happened in the driveway between the husband and wife, well, maybe the police didn't know. So we send an investigator, and an investigator goes and talks to that person and says, hey, did you see anything? Oh, yeah. They had a crazy argument, and the husband, kicked the car, and the wife was, threw the groceries down. But was there contact between the two people? Did anyone touch the other one? No. Well, that's pretty important for a prosecutor. So Again, waivers of prosecution do not mean that when the state attorney receives it that the case is going to be dismissed, but it does mean that there's some additional information that the state should be aware of, the state attorney prosecuting the case should be aware of. And as a defense attorney, it's my job to get them that information if I can get it. So that's a lot about waivers of prosecution. You can usually get them from a defense attorney. You can usually get them from the state attorney's office. You can usually get them from the victim advocate that's assigned to the case. If you need one, contact any of those parties and they'll provide them. Just know that as a defense attorney, no one can give you legal advice as a victim unless you're specifically hired to represent the victim. So if a victim was to come into my office and say, hey, listen, John Smith is representing my husband and I'd like to retain you. Well, yes, I would charge him a small fee. I would spend the time. I would walk through the facts with them and I would explain things. But when an alleged victim contacts the same attorney as that's representing their loved one, that attorney has a conflict and cannot give any legal advice. So I'm attorney Roger P. Foley. That's Waivers of Prosecution. Thanks for listening.